Hey y'all, loud little ducky. We are going to be going over Laura Owens' arraignment in today's video. She is currently facing criminal charges in the state of Arizona and Maricopa County. So let's dive in. All right, and so we can just refresh our memory. Let's go over Owens' 7 criminal charges. She has 1 for fraudulent schemes and artifices or artifices. It's class 2 felony. This one is knowingly obtain a benefit from Clayton Echard by means of fraudulent pretenses, representations, promises, or materials, omissions. And then we have 1 forgery, which is a class 4 felony, which has to do with intent to defraud, did falsely make, complete, or alter a written instrument, to wit, which is they are mentioning the sonogram. She has 4 perjury charges, which are also class 4 felony charges. One is a false sworn statement in front of Judge Duty. Another one is claiming that a sonogram image was hers during a deposition. There's a video clip of father touching a pregnant belly, and she is saying that it is hers when it is not. And claiming that's me showing my pregnant stomach, which is to me the pictures I believe that her attorney put up of her standing weird in front of a mirror or in a bathroom where the door is all funky. I think it's that one. And then she has 1 tampering with physical evidence, which is a class 6 felony, which is the intent that it be used, introduced, rejected, or made available in an official proceeding, which was then pending. Laura Owens knew was about to be instituted and did destroy, mutilate, alter, conceal, or remove physical evidence. Those may be talking about the pictures that were used at the June 10th hearing with the intent to impair its verity or availability. So those are her counts. We did do a whole video on her indictment, which is in the Clayton Echard playlist, but I think I'm also going to make a separate playlist that just is Owens' criminal case all by itself, so that we have the paternity case and this separate, like I've done with the other victims of Laura Owens. This was the minute entry order that was put out saying that the camera coverage is permitted in the courtroom solely for the purpose of the 5/29/25 arraignment hearing in the above entitled matter in this division. All authorized persons with cameras shall comply with all provisions of Rule 122, whether court is in session or not. There shall be no use of flash bulbs, strobe lights, or other artificial lights anywhere in the courthouse. There shall be no use of cameras in any hallway, stairwell, elevator, cafeteria, or other public-private area of the courthouse without specific judicial approval, all in accordance with the prior administrative orders of the court. It is further ordered that live feeds shall only be for distribution purposes, and is further ordered that there shall be only 1 camera of each medium, 1 still and 1 video, and it is further ordered that no broadcast of any kind may occur until 30 minutes after the conclusion of the day's proceeding. So that was saying that it can be broadcast and, and that it could be recorded. And we are well beyond 30 minutes after this day's conclusion of the proceedings. All right. So we're going to watch the arraignment video. It is fairly quick and it's just basic. And then we will go over the documents that pertain to this hearing after we watch this real quick.
Number 1, Owens, private attorney on case.
This is number 1 on the court's calendar, State of Arizona versus Owens, CR 2025-006-831-001. Ms. Owens, would you please state your full name and date of birth?
Laura Michelle Owens, 5/14/1990.
Thank you. Counsel, would you please announce?
Yes, thank you, Judge. Matthew Smiley for Joshua Colesberg for the defendant who is present via Teams.
Thank you. Counsel, do you waive a reading this morning?
I do.
Court will
Judge Nicole Northup on behalf of Ed Leiter for the state.
Oh, thank you. This morning, the court will enter pleas of not guilty on behalf of the defendant as to all counts 1 through 7, noting that this is the initial appearance on each of those counts. Court dates will be set as follows. Initial pretrial conference, July 11th at 8:15 with Commissioner Garfinkel. Comprehensive pretrial conference, August 11th at 9 a.m. with Judge Reeder. Final trial management conference, October 16th at 9 a.m. with Judge Reeder. Trial assignment is October 23rd at 9 a.m. before the master calendar assignment judge. Current last day is November 25th. Court needs to set release conditions on these matters, or I'm sorry, on these counts. I'll hear from the state first.
Judge, she's OR right now, is that correct?
There have been no release conditions set, so she's responding to a summons.
Okay. The state would ask that she be released to pretrial services.
Thank you. Counsel?
Judge, she's responded to the summons. I don't believe she has a prior criminal history. We'd ask for OR release.
The defendant will be released on her own recognizance, ma'am. What that is your promise to attend all future court hearings. You don't need to post a bond at this time. However, if you fail to appear for any of your future court hearings, absent good cause, court could issue a bench warrant for your arrest and require that you post a bond if you are taken into custody before you can be released. Court will also order that you not initiate any contact with any alleged complainant or witness. You're not to possess any drugs without a valid prescription. Do not drive a motor vehicle without a valid driver's license. You're not to leave the state, at least not without permission. You need to continue to provide the court with proof of a local address, continue residing at that address. Looks like you've already taken care of your fingerprints. Counselor, is there anything further from the state?
No, Your Honor, thank you.
From the defense?
No, thank you, Judge.
All right, thank you.
So that is her arraignment. It is a very quick thing. It doesn't take long. They waived the reading of the charges because she already has gone over them with her lawyer and probably just doesn't want them stated on the record again. But yeah, that arraignment hearings are not very long. That is a typical arraignment hearing. But let's go over the documents. Okay. So we have the Honorable Ashley Rahman in the Superior Court of Arizona, State of Arizona versus Laura Owens. It has the attorneys listed as well. This is the not guilty arraignment because that is how Owens pled. It gives, it was at 8:53, the courtroom it was in. State's Attorney Nicole Leiter, the Owens attorney for that, which he was subbing in, I believe, Matthew Smiley, and Owens was present via Court Connect. A recording of the proceeding is made digitally in lieu of a court reporter Defendant was present for the group advisement given on the record at 8:47 a.m. This date in this courtroom. Defense counsel waived formal reading of the charges, which is what I thought because we didn't hear them. It is ordered entering a not guilty plea to all charges on behalf of the defendant at this time. In preparation for the initial pretrial conference, the parties shall do the following. The defense attorney shall conduct a conflicts check within the office to determine whether a conflict exists. If a conflict exists, counsel shall staff the conflict with the appropriate supervisor, and counsel shall file the appropriate motion to withdraw so new counsel can appear at the initial pretrial conference. I don't think we have any of that here, but 2 motions to modify release conditions shall be heard at the initial pretrial conference. Motions shall be filed with the assigned commissioner not later than 10 days prior to the initial pretrial conference. 3, if a plea agreement is extended by the state shall extend the plea not later than 10 days before the initial pretrial conference. Defense counsel shall make reasonable efforts to present the plea to in-custody defendants before the initial pretrial conference. She is not in custody. She is out on her own recognizance. 4, a motion for Rule 11 evaluation shall be heard at the initial pretrial conference. Motion shall be filed with the assigned commissioner not less than 10 days before the initial pretrial conference. 5, defense counsel shall prepare and file a list of specific items of discovery required under Rule 15.1b, but which were not disclosed. See Rule 15.2c, or 15.2e. Such list shall be filed with the assigned commissioner not less than 5 days before the initial pretrial conference, which the state has filed theirs, and we will be looking at that in another video. 6, all electronic media, audio tapes, CDs, etc., or documents which require language translation shall be submitted to the court interpretation and translation department on or before the initial pretrial conference hearing, which they shouldn't have to do because everybody speaks English in this case, from my understanding, unless there's a witness that works on the horsey farm that doesn't. Any motion to modify release conditions or Rule 11 motions not filed before the initial pretrial conference will be heard at the comprehensive pretrial conference before the designated master calendar judicial officer. All motions shall be in writing with specific facts to support the motions. This case is assigned to Judge Reuter, which we heard that in the arraignment video. The judge went over all that. It is further ordered setting an initial pretrial conference for July 11, 2025 at 8:15 a.m. before Commissioner Garfinkel, which 7-Eleven is just right around the corner. It is ordered setting a comprehensive pretrial conference for August 11, 2025 at 9 a.m. before Judge Reuter. Again, these are things that the judge went over in the arraignment video that we watched on the record. As to counts 1 through 7, for which the court conducts an initial appearance this date, it is ordered releasing the defendant on his or her own recognizance. It is ordered that attorneys for both the state and defense be prepared to provide the court with the following information at the comprehensive pretrial conference. A status of plea negotiations. This includes whether or not the state has tendered an offer. If so, when it expires, the results of settlement conference, and whether or not a Donald advisement is required. B, the status of disclosure by both the state and defense. This includes what discovery has been disclosed and what discovery still needs to be disclosed. If any discovery is left undisclosed, it is required that all parties comply with Rule 15.6 and provide appropriate affidavits. We have not seen the defense's discovery disclosure. The state put theirs in, and let's see, that is due 5 days. So it is due by Sunday at the latest. If they count business days, it's due possibly by tomorrow because Friday is a holiday. So we should be seeing that very soon as well, and we will go over that. The number of days required for trial, and it's just an estimate. The number of witnesses to be used at trial, including any out-of-state witnesses, and the number of expert witnesses to be used at trial. That was also disclosed by the state. The status of interviews. This includes how many interviews have been conducted and how many are left to complete. This includes whether or not any depositions are going to be required. If depositions are required, it is ordered that the party file a motion requesting same no later than 2 days before the comprehensive pretrial conference date. Whether or not an interpreter is going to be required for a witness or a defendant, the number of jurors required for a trial along with recommended number of alternates, whether or not the state is requesting an aggravating factors trial to the jury, any special jury instruction, whether or not either party is requesting a lesser included offense, whether or not there are any anticipated substantive motions to be filed by either party, whether or not there are motions in limine anticipated. It is further ordered setting a final trial management conference on October 16, 2025 at 9 a.m. before Judge Reuter. It is ordered setting trial assignment date as October 23, 2025 at 9 a.m. before the master calendar assignment judge. The trial assignment hearing is in person for all lawyers and defendants. The parties should contact the trial assignment division prior to the trial assignment date to request to appear virtually. The purpose of the hearing is to set dates for 1, the trial procedure conference, and 2, the jury selection date. All self-representative litigants shall appear in person at the trial assignment date unless otherwise ordered. All in custody defendants shall be transported unless otherwise ordered, and as of right now, Owens is not in custody. Should the trial assignment judge approve a virtual appearance, the assignment judge's division will email parties instructions and a link to join Court Connect, and they give a link. A hearing participant can also join by telephone by dialing a number and entering an access code. If virtual appearance has been approved, counsel of record and defendants are ordered to appear via video conference with their webcams enabled. So she still may not appear in person for some of these things. But we shall see. Do not dial in and try to be Owens for these things. Do not use this information wrong, because we want to conduct ourselves in a professional way when it comes to the courts, because if we have crazy people start to do crazy things, the interneting, then that makes it to where courts don't want to be transparent. And we want the courts to be transparent so that we can see these things and we can see that justice is being served and the courts are acting appropriately. And we don't have to base what's going down in court based on mainstream media's reporting, because we know how that goes. Continuing on, it says it is ordered that the defendant shall contact and meet with his or her attorneys in person no later than 3 weeks from this date for the purpose of preparing for an initial pretrial conference. So that should have already happened. Notice to the defendant. Failure to comply with the above orders may result in revocation of defendant's release from custody and or imposition of other sanctions. So you need to do what the judge tells you to do, or you can go into custody and not be released on your own recognizance. Owens, if you try to play hide the ball like you did with Judge Mata, it's not going to bode well for you. The defendant may be tried in his or her absence if he or she fails to appear for trial. I don't think she's just not going to show up. She's going to appear. I don't see her going off the grid. And last page, the defendant is advised that if convicted, the defendant will be required to appear for sentencing. If the defendant chooses not to appear and the defendant's absence prevents the defendant from being sentenced within 90 days from conviction, the defendant may lose the right to a direct appeal. I don't think that's going to be a problem for her. I don't think she's fleeing. Says last day, November 25th, 2025, the defendant is directed to appear at all scheduled court hearings and advised of the potential consequences should he or she fail to appear. 8:55 a.m. matter concludes. So they went over all of this stuff with Owens. You know what you're being charged with. This stuff is going to happen if you don't comply with these orders. Make sure you show up. Make sure you disclose information. We're not playing hide the ball. We're not playing games here. You will go to jail. You will not be able to appeal. I don't think she's going to lose her right to appeal because she's going to appear. But to let her know, we're not joking around. This isn't family court. This isn't civil court. This is criminal court. And with that, that is a wrap for Owens' arraignment and how things go. We will be putting more videos up as documents drop and covering whatever we find out on July 11th, 2025. So hit the like button, subscribe, and I will see you in the next one. Bye.